So you just found out clear out of the blue that your tenant is gone and they've abandoned all of their property. What are you going to do? That's what we're talking about today. Let's get started. Abandoned property is something that happens all of the time. And it's not always the same situation. Sometimes you have someone who's reached the end of their lease and they've packed up and gone, but they left a ton of stuff behind, and it's all stuff they just don't care about. The question is, when are you at liberty to make that decision? When does it make sense for you to touch it at all? We're going to go through a few scenarios that you can consider. You may be in the middle of one of these right now, and I'm going to teach you how you can deal with abandoned property. Now, it's important for you to be absolutely certain that what you have in front of you is, in fact, abandoned. You shouldn't just automatically assume that that's the case, because it's not always that way. Sometimes a party is in the process of moving and have no intention of abandoning that property. If you touch it before you really have a genuine right to, you may put yourself at risk for some kind of lawsuit for destruction of property, or if you change locks and assume possession of the premises, you may be guilty of an illegal lockout. And so you don't want to put yourself in harm's way when you presume something that you otherwise can't substantiate. So how can you tell the difference between I'll be back in a minute and I'm gone for good? In some instances, those provisions are found in your lease. If your lease has an abandonment clause in it, it may already define where the situation is set for you to make that determination. Not all by yourself, but by agreement. Your lease may already explain the circumstances in which you can safely assume that rental property has been unoccupied by a tenant, and that personal property left behind by that tenant is now abandoned. Your lease may say something to the following effect. In the event that the tenant is in default of the lease, and if in the reasonable estimation of the landlord, the tenant has in fact vacated the premises, any personal property left behind by the tenant may be deemed abandoned if the landlord leaves notice for the tenant, and sometimes that notice has a time frame requirement. I tend to recommend anywhere from 2 to 7 days. A week for a court would be very easy to presume that tenant simply is not coming back. But your lease may have a shorter time frame. So there's a default, and the landlord can reasonably presume that the tenant has in fact vacated, but that personal property is left behind when a written notice is left that says within 2 to 7 days, if you contact me and let me know what you plan to do with your property, I'll leave it alone. But after that point, I will presume that it is abandoned, and from that point forward, I can do whatever I want with that property, up to and including throwing it all away. If your lease already has an abandonment procedure, that abandonment clause is extremely valuable to you in a situation like this. Now, what constitutes a reasonable basis that a tenant has vacated? Well, sometimes it's as easy as them saying, hey, I'm out of here. Or you've given them a notice to vacate because of that default. Again, you can frame the reasonableness based on the communication that the tenant has had with you or that you have had with them. If it appears that the tenant has in fact vacated and you've left that notice in accordance with your lease, and you haven't heard a response from them, then you can safely assume under these circumstances that the property has been abandoned, and you can clear out the unit of that property and discard everything that has been left behind. And the reason that it's important to follow this procedure to the T is because you don't want the tenant later to come back and file some claim against you for illegally touching or moving their property. And certainly you don't want them to make the claim that you threw away tens of thousands of dollars of their personal property that they absolutely meant to come back for. By following the procedure, you insulate yourself from these kinds of claims. Every single week you're going to find me here with brand new content about the landlording business. If you like what you see, give us one of these. We enjoy that. And if you haven't subscribed yet, please consider subscribing. Any questions or comments, I will personally respond to those myself. But how do you prove that you left proper notice? Well, sometimes a notice in the lease is only required to be posted, usually on the inside of the main entry door. At least in the state of Texas, this is a common provision where if a notice is posted on the inside of the main entry door, it is likely that any returning tenant will see that notice and be able to respond adequately. But if you have multiple ways of getting a hold of your tenant, email, text, just pick up the phone, maybe you mail a letter to the residents, each of these things will serve as backup to the fact that you did, in fact, post that notice to the inside of the main entry door. I would recommend taking a picture of it, maybe even with some method of determining the date, like the newspaper or some other timestamp method. And this is why email and text are great, because they'll record the time that the message was delivered. And I always tell landlords, you can never give too much notice. You can only ever give too little. So don't be afraid of over notifying the tenant of your intent to toss everything out. You may actually get their written response, no problem, I didn't want any of that stuff anyway. Now, you may also be asking yourself, well, what if they did it intentionally? What if they left all of their junk behind that of course they're never going to come back for, and I incur fees from that junk? Well, follow your lease. Your lease may already have a provision in there that allows you to deduct certain costs from the security deposit. But wait, you may be telling me there is no security deposit, or they already owe me so much in unpaid rent that the security deposit is already used up. Well, just like in any case where a tenant leaves more damage than security deposit to cover that damage, this is another claim that you might add to the list of claims that you already have against that tenant, and you may decide to file a lawsuit, or you may just waive these claims. The truth is, if you can charge your tenant for cleaning up their mess, then you should. Now, when else does abandonment come into play? Well, it has to do with the eviction process. If you've begun the eviction process and you're somewhere in the middle of it, you haven't quite reached the end, and you suspect that your tenant has vacated, well, you have every right to go and inspect your property. Typically, these are rights that are clearly delineated in your lease. So follow those procedures. If they require that you send out notice, do that. If you can inspect your property without having to give notice, then you're free to do that. But again, you're better off sending more notice than needed than less notice than needed. It's helpful for you to attempt to communicate with the tenant, because if you come upon a property and you have a reasonable expectation that that tenant has left, but you assume control, again, there are risks. But let's say you do have a judgment. In fact, let's say that you've obtained a writ of possession, which is the writ at the end of an eviction in a Texas court that gives you the opportunity to regain possession. To exercise that writ, you're going to need the constable in place coordinating with you to remove that tenant. Let's say you show up on the day of the writ and stuff is there. In Texas, the procedure is the constables are there to remove people. You are there to remove their stuff. So I always tell landlords, be prepared on the day that your writ of possession is being exercised with the moving crew ready to get people out. If they have left but abandoned property and you're exercising a writ of possession, you're better off waiting until the constables are there with you. That is your safest bet. Even if you have an abandonment clause in your lease, you're going to want to wait for the constables to sign off on the fact that they showed up and yes, the property was otherwise abandoned and the landlord took possession. Because again, you don't want someone saying, well, yes, there was a provision in the lease for this abandonment procedure, but you didn't follow it. Instead, if you've got the notes of the constable when the writ of possession was executed, explicitly stating that you took possession based on that writ, you are covered. So whether or not you have that provision in your lease, the exercising of the writ of possession covers you from these claims. If you don't have an abandonment clause in your lease, it's going to be a little bit difficult, but some of the same principles apply. Without an abandonment clause in your lease, you may elect to give reasonable notice, I would say at least 1 week, in multiple ways, one of which can be posting the notice to the inside of the main entry door. But if you have multiple avenues for contacting that tenant, do so. Text, email, regular mail, any way that you can get a hold of them, even through voicemail, do all of them. Don't just do 1 or 2. If you've got 3 or 4, do them all. If you have a work address, send the notice to the tenant there. Because you want to be able to demonstrate to the court that you have made every reasonable effort to contact them. Again, you may not have this provision in your lease, but by following these steps, you may be able to help yourself out and save yourself 1 or 2 months of time. You don't have to wait until the very end. Again, if you have a reasonable basis for believing that the tenant has in fact abandoned the property and you've taken reasonable steps to notify them about your intent to re-enter the property and assume that their personal property is otherwise abandoned, then you can take these steps with the understanding that if you can prove what you've done and if everything you've done is reasonable, that the court is likely to find in your favor. Now, naturally, you always want to do these things with the understanding that you can be sued. But by taking each of these steps, you protect yourself from any kind of lawsuit like that. For even more information about the kinds of things you should be doing as a professional landlord, YouTube seems to think that this video right here is right up your alley. I suggest you watch it and all the other content that you find on this channel. And until next time, landlords, happy leasing.